I never thought a piece of paper taped to my front door would turn my entire life into a legal nightmare. But when I saw that Lien notice from the Riverside Meadows Homeowners Association, I knew my peaceful existence in Phoenix, Arizona, was about to get a whole lot more complicated. My name is Ethan Winters, and I had been living in my modest 3-bedroom house in the Riverside Meadows subdivision for about 4 years. The neighborhood was nice enough, with its manicured lawns and identical beige fences. I worked as a software developer for a tech company downtown, spending most of my days in front of a computer screen and my evenings trying to maintain some semblance of a normal life. I was 32 years old, recently divorced, and honestly just trying to keep my head down and rebuild my life one day at a time. The problem started on a Tuesday morning in March when I was running late for work. I had overslept, spilled coffee on my shirt, and was frantically searching for a clean replacement when I opened my front door to grab the newspaper. That was when I saw it. A bright yellow notice, professionally printed and laminated, taped right at eye level on my door. The header read "Notice of Lien for Unpaid HOA Assessments" in bold, threatening letters. My heart sank as I ripped the notice off the door, the tape leaving a sticky residue on the paint. According to this document, I owed the HOA $1,200 in unpaid quarterly assessments, late fees, and administrative charges. They claimed I had not paid my HOA dues for the past 6 months, and that they were now filing a lien against my property. If I did not pay within 30 days, they threatened to foreclose on my house. The thing was, I had paid my HOA dues, every single one of them. I was meticulous about my finances, especially after the divorce when I had to rebuild my credit and get my life back on track. I had automatic payments set up through my bank, and I had confirmation emails for every single payment. This had to be some kind of mistake. I called in sick to work, something I rarely did, and immediately started digging through my files. I found all my bank statements showing the payments had been withdrawn from my account like clockwork every quarter. I had the confirmation numbers. I had everything. Armed with this evidence, I drove straight to the HOA management office, which was located in a strip mall about 3 miles from my neighborhood. The office was small and cramped, with fake wood paneling on the walls and outdated furniture that looked like it came from a yard sale. Behind the desk sat a middle-aged woman with severely highlighted blonde hair pulled back in a tight ponytail. She wore a floral blouse that was at least 2 sizes too small and had reading glasses hanging from a beaded chain around her neck. Her nameplate read, "Brenda Morrison, HOA Board President." "Can I help you?" she asked without looking up from her computer screen, her voice dripping with the kind of dismissive tone that immediately put me on edge. "Yes, I received this notice this morning," I said, placing the yellow paper on her desk. "It says I owe $1,200 in unpaid assessments, but I have paid everything. I have proof right here." Brenda finally looked up at me, her lips pursed into a thin line. She picked up the notice with 2 fingers as if it might contaminate her, glanced at it for about half a second, and then looked back at me with an expression that could only be described as condescending pity. "Mr. Winters, is it? Our records show that you have not paid your assessments for 2 consecutive quarters. That is our policy. If payment is not received, we file a lien. It is very simple." "But I have paid," I insisted, pulling out my bank statements. "Look, here are the transactions. March 15th, June 15th, September 15th, December 15th. Every payment went through. I have the confirmation numbers from the HOA payment portal too." Brenda took the papers from me with obvious reluctance. She barely glanced at them before sliding them back across the desk. "These could be from anything. Our system shows no record of receiving these payments. Perhaps you sent them to the wrong account. Perhaps your bank made an error. Either way, according to our records, you owe this money and the lien stands. I felt my blood pressure rising. Then check your system. There has to be a mistake somewhere. Can you pull up my account history? She sighed heavily, as if I was asking her to move mountains, and turned back to her computer. She clicked around for a few moments, her long acrylic nails tapping loudly on the keyboard. No payments recorded for the past 6 months. As I said, the lien stands. You have 30 days to pay in full, including the administrative fees for processing the lien and the late charges. This is insane, I said, trying to keep my voice level. I am not paying for something I already paid. I want to speak to whoever is in charge of the accounting. I am in charge, Brenda said flatly. I am the board president and I oversee all HOA operations. If you have a complaint, you can file it in writing and we will review it at our next board meeting, which is not until next month. Until then, the lien remains in effect. Next month? Are you kidding me? This lien is affecting my credit right now. It is on public record. This needs to be resolved immediately. Brenda stood up from her chair, her expression hardening. Mr. Winters, I do not appreciate your tone. If you continue to be hostile, I will have to ask you to leave. The HOA has procedures and we follow them. If you believe there has been an error, you are welcome to hire an attorney to review the matter, but until we receive payment or a court order stating otherwise, the lien stands. Now I have other work to do. Good day. I stood there for a moment, stunned by her complete dismissal of clear evidence. I wanted to argue more, to demand she actually look at my proof, but I could see it would be pointless. This woman had made up her mind, and nothing I said was going to change it. I gathered my papers and left the office, my hands shaking with frustration and anger. Over the next few days, I tried everything I could think of to resolve the issue on my own. I called my bank and confirmed that the payments had indeed been processed and sent to the correct account number provided by the HOA. The bank even provided me with images of the canceled checks showing they had been deposited into the HOA's account. I called the HOA management company that Riverside Meadows contracted with, but they just referred me back to Brenda, saying she had full authority over the account. Meanwhile, the lien was already causing problems. I had been in the process of refinancing my mortgage to get a better interest rate, and the lien immediately killed that application. The mortgage company called me to explain that they could not proceed with a property lien on record. I also started receiving letters from the HOA's attorney, a firm called Davidson and Associates, demanding payment and threatening foreclosure proceedings. That was when I realized I needed professional help. I could not fight this on my own, not when they had lawyers and I was just one person trying to prove something that should have been obvious from the start. I started researching real estate attorneys in Phoenix, looking for someone who specialized in HOA disputes. After reading through dozens of reviews and websites, I found a lawyer named Marcus Rodriguez who seemed perfect for the case. His website featured several testimonials from clients who had won cases against overreaching HOAs, and he offered a free initial consultation. I called his office on a Friday afternoon and was surprised when he answered the phone himself. His voice was warm and professional, and he listened patiently as I explained the entire situation. When I finished, he was quiet for a moment before speaking. Mr. Winters, I have seen cases like this before, and unfortunately, they are becoming more common. Some HOA board members get a little power, and it goes straight to their heads. They think they can do whatever they want without consequences. From what you are telling me, You have solid documentation that you made these payments. The fact that they are refusing to even investigate their own records is a red flag. Can you come into my office on Monday morning? I would like to review all your documentation in person, and we can discuss how to proceed. I felt a wave of relief wash over me. Finally, someone was taking me seriously. Yes, absolutely. What time? How about 9 o'clock? My office is downtown on Jefferson Street. Bring everything you have, bank statements, confirmation emails, any correspondence with the HOA, copies of the Lien notice, everything. That weekend felt like it lasted forever. I spent most of it organizing all my documents, creating a timeline of events, and trying not to spiral into anxiety about what would happen if I could not get this resolved. I had worked so hard to get my life back on track after the divorce, and the thought of losing my house over a clerical error was overwhelming. Monday morning arrived, and I drove downtown to Marcus Rodriguez's office. It was located in a modern glass building, and his suite was on the 14th floor. The waiting area was tastefully decorated with comfortable chairs and contemporary art on the walls. A receptionist greeted me with a genuine smile and offered me coffee while I waited. Marcus came out to greet me personally a few minutes later. He was in his mid-40s, with salt and pepper hair and an easy confidence that immediately put me at ease. He wore a well-tailored navy suit and had the kind of firm handshake that inspired trust. "Ethan, good to meet you in person," he said, gesturing for me to follow him into his office. "Let us take a look at what we are dealing with." For the next hour, Marcus went through every document I had brought. He took notes, asked detailed questions, and periodically nodded to himself as if confirming something he already suspected. Finally, he leaned back in his chair and looked at me directly. "Okay, here is what I think is happening. Your payments were made and received. That much is clear. The bank records show the money left your account and was deposited into the HOA's account. The question is, what happened to it on their end? Either they have a serious bookkeeping problem, or someone is deliberately misrepresenting your account status. Given the way this Brenda Morrison person dismissed your evidence without even looking at it properly, I am leaning toward the latter." "Why would they do that?" I asked. "What do they gain from falsely claiming I did not pay?" Marcus shrugged. "Could be a few reasons. Some HOAs use aggressive lien policies to generate revenue through late fees and legal costs. Others do it as a power play. Some board members just enjoy having control over their neighbors. Without more information, it is hard to say. But here is what we are going to do. First, I am going to send a formal demand letter to the HOA and their attorney, providing all of your payment documentation and demanding that they immediately release the lien. I am also going to request a full accounting of your HOA account and an explanation for why your payments were not properly credited." "Do you think they will respond?" I asked. "They will have to respond to something," Marcus said with a slight smile. "Because if they do not release the lien voluntarily, we are going to file a lawsuit. We will sue for wrongful lien, and depending on what we uncover during discovery, we might have claims for negligence, breach of fiduciary duty, and possibly defamation if they have been making false statements about your payment history to third parties." "Defamation? How?" "Well, think about it. They filed a public lien claiming you failed to pay your debts. That is a matter of public record. Anyone can look it up. It affects your credit, your reputation, your ability to do business. If that claim is false and they knew or should have known it was false, that is defamation. It is slanderous to make false statements that damage someone's reputation, especially in a business or financial context." The idea had not even occurred to me, but Marcus was right. The lien was not just a private dispute between me and the HOA. It was public record. Anyone who ran a credit check or property search on me would see it and assume I was someone who did not pay my bills. That was exactly the opposite of who I was. "How long will all of this take?" I asked. "The demand letter will go out today. They will have 10 days to respond. If they release the lien and apologize, we can probably negotiate a settlement for your damages without filing suit. If they dig in their heels, we will file the lawsuit, and then we are looking at several months of litigation, maybe longer if it goes to trial." But honestly, most of these cases settle once the HOA realizes they are going to lose. The key is we have the evidence on our side. I left Marcus's office feeling cautiously optimistic. He was expensive with a $5,000 retainer fee, but he seemed competent and confident. I paid the retainer with my credit card, wincing at the charge but knowing I had no other choice. This was my home at stake, my financial future, my reputation. I had to fight. True to his word, Marcus sent the demand letter that same day. He emailed me a copy, and I was impressed by how thoroughly it laid out the facts and the law. It included copies of all my payment records, highlighted the relevant statutes about wrongful liens, and gave the HOA 10 days to release the lien and provide a written explanation for their error. The 10 days crawled by with no response from the HOA or their attorney. I called Marcus's office several times for updates, but there was nothing to report. The HOA was simply ignoring the demand letter, which Marcus said was not uncommon but also not a good sign. It meant they were either incredibly incompetent or incredibly arrogant, neither of which boded well for a quick resolution. On day 11, Marcus filed the lawsuit. The complaint was filed in Maricopa County Superior Court and named both the Riverside Meadows Homeowners Association and Brenda Morrison individually as defendants. The claims included wrongful lien, breach of fiduciary duty, negligence, and defamation. Marcus also filed a motion for a temporary restraining order to force the immediate removal of the lien pending the outcome of the case. The first hearing on the temporary restraining order was scheduled for 2 weeks later. In the meantime, I had to continue living with the knowledge that my property had a lien on it and that my financial reputation was being trashed through no fault of my own. I had trouble sleeping, lost my appetite, and found it hard to concentrate at work. My boss noticed and asked if everything was okay. I gave him a vague explanation about some legal issues with my HOA, and he was sympathetic but clearly concerned about my performance. The day of the hearing arrived, and I met Marcus at the courthouse. It was a massive concrete building downtown, with security checkpoints and metal detectors at the entrance. We went through security and took the elevator up to the 6th floor, where the civil courtrooms were located. The hallway was crowded with lawyers, clients, and court staff, everyone moving with purpose and urgency. We found our courtroom and took seats in the gallery. Brenda Morrison was there with the HOA's attorney, a man in his 60s with silver hair and an expensive suit. He looked like the kind of lawyer who had been doing this for decades and was not easily impressed or intimidated. Brenda, for her part, looked annoyed to be there. She kept checking her watch and whispering to her attorney with visible impatience. The judge, a no-nonsense woman in her 50s named Judge Patricia Sullivan, called our case. Both attorneys approached the bench and introduced themselves for the record. Marcus went first, presenting the motion for the temporary restraining order and walking the judge through the evidence of my payments. "Your Honor, my client has provided clear and convincing evidence that he made all required HOA payments. The bank records show the funds were withdrawn from his account, and deposited into the HOA's account. Despite this, the HOA has filed a lien claiming non-payment and has refused to correct their error even when presented with proof. This lien is causing immediate and irreparable harm to my client's credit, his ability to refinance his property, and his reputation. We are asking the court to order the immediate release of the lien pending a full hearing on the merits. The HOA's attorney, who introduced himself as Donald Davidson, responded with what I can only describe as dismissive arrogance. Your Honor, the HOA has a right to file liens for non-payment of assessments. Our records show no payment was received. The plaintiff claims he made payments, but there could be any number of explanations for a discrepancy. Perhaps he sent the money to the wrong account. Perhaps there was a bank error. The HOA should not be penalized for the plaintiff's inability to properly transmit payment. Judge Sullivan looked up from the documents in front of her with a raised eyebrow. Counselor, I am looking at bank records showing deposits into the HOA's account. How do you explain that? Davidson seemed taken aback by the question. I have not had the opportunity to fully review the financial records, Your Honor. I would need time to have the HOA's accountant examine these documents. So you filed a lien without verifying whether payment had actually been received? The judge asked, her tone making it clear she was not impressed. The HOA board relied on the information provided by their management system, Davidson replied, his confidence clearly shaken. Judge Sullivan flipped through a few more pages, then looked directly at Brenda Morrison. Miss Morrison, you are the board president, correct? Brenda stood up awkwardly. Yes, Your Honor. Did you personally review Mr. Winters's payment history before filing this lien? I looked at what our system showed, Brenda said defensively. The system said he had not paid, so I proceeded according to our policies. And when Mr. Winters came to your office with bank statements showing he had paid, did you investigate further? Brenda hesitated. I told him our records showed otherwise. I assumed there must have been an error on his end. You assumed, Judge Sullivan repeated, letting the word hang in the air. You assumed, rather than actually verifying the facts before maintaining a lien that is damaging this man's credit and financial standing. The courtroom was silent. Brenda's face turned red, and Davidson looked like he wanted to be anywhere but there. Here is what is going to happen, Judge Sullivan said firmly. I am granting the temporary restraining order. The HOA is ordered to release the lien immediately, no later than close of business tomorrow. You will file the release with the county recorder's office and provide proof of filing to plaintiff's counsel. This case will proceed to a full hearing on the remaining claims. Counselor Davidson, I strongly suggest your client conduct a thorough audit of their financial records before we meet again. This court does not look kindly on liens filed without proper verification. We are adjourned. She banged her gavel, and just like that, it was over. I felt like I could breathe for the first time in weeks. Marcus turned to me with a satisfied smile. That went well. That is an understatement, I said, relief flooding through me. She destroyed them. Judge Sullivan does not tolerate lazy lawyering or sloppy record-keeping, Marcus explained as we gathered our things. The fact that they filed a lien without verifying the accuracy of their records really bothered her, as it should. Now they are on the defensive. Let us see how they respond. As we walked out of the courtroom, I noticed Brenda glaring at me from across the hallway. She was talking animatedly to Davidson, gesturing with her hands and clearly agitated. I did my best to ignore her, but I could feel the hostility radiating from her direction. The next day, Marcus called to confirm that the HOA had filed the lien release with the county recorder's office. It was official. The lien was gone. I immediately contacted my mortgage company to let them know, and they were able to restart the refinancing process. Things were finally starting to look up, but the story did not end there. About a week after the hearing, I ran into my neighbor, Tom Chen, while I was checking my mail. Tom was a friendly guy in his late 50s who had lived in the neighborhood for over a decade. He knew everyone and was always up to date on the local gossip. "Hey, Ethan," he called out as he walked over. "I heard you had some trouble with the HOA." "Yeah, they filed a bogus lien on my house," I said, "but my lawyer got it removed." Tom looked uncomfortable. "I do not know if I should tell you this, but Brenda has been going around the neighborhood telling people you are a deadbeat who does not pay your bills. She said you lawyered up to bully the HOA into dropping legitimate charges. She has been pretty vocal about it at the community pool and the last few board meetings." I felt my stomach drop. "She is saying what?" "She has been telling people you are trouble, that you do not pay your assessments, that you are trying to scam the HOA. A couple of people have asked me about it because they know we are neighbors. I told them I did not believe it because you have always been a good guy, but she is definitely spreading stories." I thanked Tom for the information and immediately called Marcus. When I told him what Brenda had been saying, he went quiet for a moment. "That is incredibly stupid of her," he finally said. "She just turned a simple wrongful lien case into something much bigger. If she is making false statements about you to third parties, that is textbook defamation. And if she is doing it after a judge ordered the lien removed, that shows malice. This just got a lot more serious for her personally." "What do we do?" I asked. "We amend our complaint to add more specific defamation claims and add allegations about these new statements. I am also going to move to depose Brenda and anyone else she has been talking to. If we can get people to testify that she made these statements, we have her dead to rights. Defamation is taken very seriously, especially when it involves false accusations about someone's financial responsibility. That strikes at the heart of someone's reputation and ability to do business." Over the next few weeks, Marcus worked on amending the complaint and gathering evidence of Brenda's statements. He hired a private investigator who interviewed several neighbors and got signed statements from 3 people who had heard Brenda make disparaging comments about me. One neighbor, a woman named Susan Phillips, said Brenda had called me a con artist at a board meeting and suggested other homeowners should watch out for me. Another neighbor, Michael Torres, said Brenda had told him I was the kind of person who thinks he is above the rules and does not have to pay his fair share. The amended complaint was filed, and this time it included specific allegations of slander with actual quotes from witnesses. Marcus also filed a motion to depose Brenda and the other board members to get their testimony on record about what happened with my account and what statements they had made about me. The deposition was scheduled for a month later at Marcus's office. It was my first time attending a deposition, and I was not sure what to expect. Marcus explained that a deposition was basically a formal interview under oath where the other side's lawyer gets to ask questions, and everything is recorded by a court reporter. The transcript can then be used as evidence in the case. Brenda arrived for her deposition with Davidson, both of them looking considerably less confident than they had at the courthouse. The deposition took place in a conference room at Marcus's office, with just the 5 of us, a court reporter, and a video camera to record the proceedings. Marcus started with basic background questions about Brenda's role in the HOA, how long she had been on the board, what her responsibilities were. Brenda answered tersely, clearly not happy to be there. Then Marcus started asking about my account specifically. "Miss Morrison, when did you first become aware that Mr. Winters allegedly had unpaid assessments?" I do not remember the exact date. It would have been sometime in February when I ran the delinquency report. And what did that report show? That he had not paid for 2 quarters. Did you verify that information before filing the lien? Brenda shifted in her seat. I relied on the report generated by our management software. Did you personally check to see if any payments had been deposited into the HOA's bank account? No, I trusted the software. Did you ask anyone else to verify the information? No. So you filed a lien based solely on what a computer program told you without any independent verification, Davidson interjected. Objection. Argumentative. Marcus nodded. I will rephrase. Is it correct that you did not independently verify the payment status before filing the lien? That is correct, Brenda admitted. And when Mr. Winters came to your office with bank statements showing he had made the payments, what did you do? I told him our records showed otherwise. Did you investigate further? No. Why not? Because I believed our system was accurate, even when presented with evidence to the contrary. I thought maybe he had made an error. Marcus leaned forward slightly. Miss Morrison, did you ever actually look at the bank statements Mr. Winters provided to you that day? Brenda paused. I glanced at them. You glanced at them. Did you examine them in detail? No. Did you pull up his account in your system to compare the information? No. Did you contact your bank to verify whether deposits matching his payments had been received? No. So you did nothing to actually investigate his claim that he had paid. Is that correct? Brenda's jaw tightened. I told him to put it in writing and we would review it at the next board meeting. Which was not for another month, correct? Yes. And in the meantime, the lien remained on his property, damaging his credit and preventing him from refinancing his mortgage. I suppose so, yes. Marcus then moved on to the statements Brenda had made about me to other neighbors. He pulled out the witness statements one by one. Miss Morrison, did you tell Susan Phillips that Mr. Winters was a con artist? Brenda's eyes widened slightly. I do not recall saying that. You do not recall, or you did not say it. I might have expressed frustration about the situation. Did you or did you not use the words con artist to describe Mr. Winters? I do not remember my exact words. Marcus slid a copy of Susan's statement across the table. Miss Phillips has provided a sworn statement that you used those exact words at a board meeting on April 12th. Were you at that board meeting? Yes. And did you discuss Mr. Winters' case at that meeting? Yes, briefly. What did you say about him? I do not remember exactly. I was frustrated that he was suing the HOA. Did you tell other homeowners to watch out for Mr. Winters? I might have suggested that people should be aware of the situation. Aware that Mr. Winters was suing the HOA for wrongfully filing a lien, or aware that he was somehow dangerous or dishonest. Davidson objected again, but Brenda answered anyway. I was concerned about protecting the HOA and the other homeowners. Protecting them from what? From a man who paid his bills and was wrongfully accused of not paying. I did not know that at the time. You did not know, or you did not want to know, because you had been provided evidence of his payments, correct? I had been provided some documents, yes. Documents from his bank showing payment, and you chose not to investigate further. And then you went around the neighborhood telling people he was a con artist who did not pay his bills. Is that accurate? That is not fair, Brenda said, her voice rising. I was doing my job as board president. I was protecting the HOA by making false statements about a homeowner who had done nothing wrong. I did not know they were false, because you chose not to investigate, even when evidence was presented to you. The deposition continued for another hour, with Marcus methodically going through every statement Brenda had made and every decision she had made regarding my account. By the end, Brenda looked exhausted and rattled. Davidson tried to rehabilitate her testimony with his own questions, but the damage was done. The transcript would show that Brenda had filed a lien without verification, refused to investigate when presented with contrary evidence, and then made defamatory statements about me to multiple people in the community. After the deposition, Marcus and I debriefed in his office. "That could not have gone better for us," he said. "She basically admitted to everything. She filed a lien without verification, ignored your evidence, and then slandered you to your neighbors. A jury is going to hate her." "Do you think it will go to trial?" I asked. "I doubt it. Now that we have her testimony on record, the HOA's insurance company is going to want to settle. They know they will lose at trial, and juries tend to award significant damages in cases like this, especially when there is malice involved. I would not be surprised if we get a settlement offer within the next few weeks." Marcus was right. About 3 weeks after the deposition, Davidson called to discuss settlement. The HOA's insurance company had reviewed the evidence and Brenda's deposition testimony and concluded that the case was unwinnable. They were willing to offer a settlement to make the case go away. The initial offer was $10,000. Marcus laughed when he told me. "That is insulting," he said. "We are going to counter with $75,000. $75,000, I repeated, shocked. "Will they really pay that much?" "They might. You have actual damages, your legal fees, the cost of the refinancing delay, the harm to your credit. But you also have reputational damages from the defamation, and you have emotional distress from the whole ordeal. Plus, we can argue for punitive damages because Brenda's conduct was willful and malicious. She knew she was wrong or should have known, and she did it anyway. Then she made it worse by slandering you. $75,000 is not unreasonable given the circumstances." The negotiations went back and forth for several weeks. The insurance company offered $25,000, then $40,000. Marcus held firm at $75,000, arguing that if we went to trial, a jury would likely award even more. He pointed to similar cases in Arizona where juries had awarded six-figure sums for wrongful liens and defamation. Finally, in early August, nearly 5 months after this whole nightmare began, we reached a settlement. The HOA and Brenda Morrison would pay me $65,000 in damages. The settlement agreement included several other terms that Marcus had insisted on. The HOA had to conduct a full audit of their financial records and implement new procedures to verify payment status before filing liens. Brenda had to send a written apology to me and to every homeowner in the community, admitting that the lien was filed in error and that her statements about me were false. She also had to resign from the HOA board immediately. The day the settlement agreement was signed was one of the best days of my life. I met Marcus at his office to sign the papers, and afterward, we shook hands. "You did great," he said. "You stood up for yourself and you won. Not everyone has the courage to fight back against this kind of abuse." "I could not have done it without you," I said, and I meant it. Marcus had been professional, strategic, and relentless in pursuing my case. The $65,000 would more than cover his legal fees and compensate me for everything I had been through. A few days later, I received Brenda's written apology in the mail. It was clearly drafted by her attorney, with formal legal language, but it said what needed to be said. She admitted that the lien was filed in error, that I had paid all my assessments in full and on time, and that her statements about me to other homeowners were false and defamatory. She apologized for the harm she had caused and stated that she was resigning from the board effective immediately. The apology was also posted on the HOA's website and mailed to every homeowner in the community. I started getting calls and texts from neighbors, many of whom I barely knew, expressing their support and congratulations. Tom Chen called to say that Brenda's apology had been the talk of the neighborhood, and that several other homeowners had come forward with their own complaints about her behavior over the years. She was a tyrant, Tom said. Everyone was afraid to stand up to her because she controlled the board. But you showed that she could be beaten. I think a lot of people are grateful for that. The new HOA board, elected in a special meeting after Brenda's resignation, was considerably more reasonable. They implemented the new verification procedures required by the settlement and hired a professional property management company to handle the day-to-day operations. The whole atmosphere of the neighborhood changed. People seemed more relaxed, less worried about getting a violation notice for some minor infraction. As for me, the settlement money gave me a significant financial cushion. After paying off Marcus's fees and reimbursing myself for the costs I had incurred, I still had over $40,000 left. I used some of it to make improvements to my house, things I had been putting off like replacing the roof and updating the kitchen. I put the rest into savings, a buffer against whatever life might throw at me next. But beyond the money, the experience taught me something important about standing up for yourself. When I first saw that Lien notice on my door, I felt helpless and overwhelmed. It would have been easy to just pay the $1,200 to make the problem go away, even though I had not done anything wrong. A lot of people probably would have done that. But paying would have meant admitting to something I did not do and letting Brenda get away with her abuse of power. Instead, I fought back. I gathered my evidence, found a good lawyer, and pursued justice through the legal system. It was not easy and it was not cheap, but it was worth it. Not just because I won money, but because I proved that I was right and that Brenda was wrong. I cleared my name and held her accountable for her actions. The legal system, for all its flaws, worked the way it was supposed to. Judge Sullivan saw through the HOA's nonsense immediately and ordered the lien removed. Marcus was able to use the discovery process to uncover Brenda's defamatory statements and build a strong case. The insurance company recognized they could not win and agreed to a fair settlement. Justice was served. I also learned a lot about HOAs and how they operate. Before this experience, I had mostly ignored the HOA. I paid my dues, followed the rules, and did not pay much attention to who was on the board or what they were doing. But HOAs have tremendous power over homeowners. They can file liens, foreclose on properties, fine residents, and make life miserable for anyone who gets on their bad side. When that power is wielded by someone like Brenda, someone who cares more about control than fairness, it can be dangerous. The good news is that HOAs are not above the law. They have to follow proper procedures, maintain accurate records, and act in good faith. When they do not, homeowners have legal remedies. It is not easy to take on an HOA, but it can be done, especially with a good lawyer and solid evidence. Looking back now, more than a year after the settlement, I can see how much I have grown from the experience. I am more confident, more willing to stand up for myself, and more aware of my rights as a homeowner and a citizen. I also have a much better relationship with my neighbors, many of whom respect me for taking on Brenda and winning. The Riverside Meadows community is a better place without Brenda Morrison on the board. The new leadership is transparent, responsive, and fair. They actually listen to homeowners and work to resolve issues rather than creating new ones. Property values in the neighborhood have gone up, in part because people know they will not have to deal with a tyrannical HOA board. As for Brenda, I heard through the neighborhood grapevine that she and her husband moved to a different part of Phoenix shortly after the settlement. Apparently, she could not handle the embarrassment of having to apologize to the entire community and admit she was wrong. Part of me feels a little bad for her, but mostly I just feel relieved that she is gone. She brought all of this on herself through her arrogance and refusal to admit mistakes. The whole experience also made me think about the nature of power and accountability. Brenda had power as HOA board president, but she abused it. She thought she could file a lien without verification, ignore evidence, and slander me with impunity. She was wrong. Power without accountability is dangerous, whether it is an HOA board president, a politician, or anyone else in a position of authority. Accountability came for Brenda in the form of a lawsuit, a devastating deposition, a forced apology, and ultimately her resignation. It came because I refused to let her get away with it, and because the legal system provided a forum for me to seek justice. Not everyone has the resources or the courage to fight back the way I did, which is why people like Brenda can get away with abusing their power for so long. But when someone does fight back and win, it sends a message. It tells other petty tyrants that they are not untouchable. It empowers other victims to come forward and seek justice. It makes communities stronger and more resistant to abuse. That is what happened in Riverside Meadows. My victory over Brenda inspired other homeowners to get involved in the HOA, to run for the board, to hold leadership accountable. The community is better for it. I also think about the role that Marcus Rodriguez played in all of this. Without a good lawyer, I would not have been able to navigate the legal system or build a strong case. Marcus knew the law, knew the procedures, and knew how to present evidence in a way that would be compelling to a judge or jury. He was not cheap, but he was worth every penny. His expertise and advocacy made all the difference. This experience taught me that investing in good legal representation is one of the smartest things you can do when facing a serious legal problem. Trying to handle it yourself, especially against an opponent who has their own lawyers, is usually a recipe for disaster. The law is complicated, and the courts have strict rules and procedures. A good lawyer knows how to work within that system to achieve the best possible outcome for their client. The settlement money, while significant, was really just a bonus. The real victory was clearing my name, holding Brenda accountable, and making sure this would not happen to anyone else. The policy changes that the HOA had to implement as part of the settlement will protect future homeowners from the kind of arbitrary and capricious behavior that Brenda engaged in. That is a legacy I can be proud of. In the months following the settlement, I became more active in the community. I attended HOA board meetings regularly, volunteered for neighborhood events, and got to know my neighbors better. I even considered running for the board myself at one point, though I ultimately decided I was not interested in that level of commitment. But I stay informed and engaged, and I speak up when I see something that does not seem right. One of the unexpected benefits of the whole experience was the relationships I formed with other homeowners. People who I had barely known before became friends and allies. We bonded over our shared frustration with the old board and our hope for a better community going forward. Tom Chen became a particularly close friend. We started having regular barbecues and watching football games together. He introduced me to other neighbors, and slowly I built a real social network in the community. My career also benefited in an indirect way. The stress of the legal battle had been immense, but getting through it made me more resilient and focused. I found that work problems that used to stress me out seemed trivial compared to what I had dealt with in the HOA case. My performance at work improved, and I even got a promotion later that year. My boss mentioned in my review that I seemed more confident and assertive, qualities that served me well in my role. The divorce that had preceded all of this had been painful, and for a long time, I felt like I was just treading water, trying to get through each day. But fighting the HOA and winning gave me a sense of purpose and accomplishment that I had been missing. It reminded me that I was capable of handling difficult challenges and coming out on top. That confidence spilled over into other areas of my life. I even started dating again, something I had not been ready for immediately after the divorce. I met a woman named Rachel at a work conference, and we hit it off immediately. When I told her the story of my battle with the HOA, she was impressed by how I had stood up for myself. "A lot of people would have just given up," she said. "The fact that you fought back says a lot about your character. We have been together for almost a year now, and things are going well." As I write this, sitting in my home office on a sunny Saturday morning, I feel grateful for how things turned out. Yes, the whole experience was stressful and expensive and frustrating. But it also made me stronger, brought me closer to my community, and resulted in real positive change. The $65,000 settlement is sitting in my bank account, earning interest and giving me peace of mind. The lien is gone, my credit is restored, and my reputation is intact. More importantly, I know that I stood up to a bully and won. I did not let Brenda Morrison or the HOA push me around. I gathered my evidence, hired a competent attorney, and pursued justice through the proper legal channels. The system worked, not perfectly but well enough. Judge Sullivan saw the truth. Marcus built a strong case, and the insurance company recognized they would lose at trial and agreed to settle. The lessons I learned from this experience will stay with me for the rest of my life. I learned the importance of keeping good records and documentation. Those bank statements and confirmation emails were crucial to proving my case. I learned that not all authority figures deserve respect or deference, and that sometimes the right thing to do is to stand up and fight back. I learned that the legal system, while imperfect, can deliver justice when you have the facts on your side and good representation. I also learned about the importance of community. My neighbors rallied around me once they learned what was happening. They provided witness statements, moral support, and friendship. Tom Chen checked in on me regularly during the worst of it, making sure I was okay and offering encouragement. Susan Phillips and Michael Torres were willing to give sworn statements about Brenda's defamatory comments, even though doing so might have made them targets of her wrath. The experience also taught me about the dangers of unchecked power in small organizations like HOAs. These associations govern millions of Americans, yet they operate with relatively little oversight or accountability. Board members like Brenda can abuse their power for years because most homeowners do not have the time, resources, or knowledge to fight back. The legal costs alone are enough to deter most people from challenging HOA decisions, even when those decisions are clearly wrong. That is why what happened in my case matters beyond just my individual victory. It showed that HOAs can be held accountable, that board members can be sued personally for their actions, and that courts will protect homeowners from abuse. It set a precedent in our community and hopefully encourages others in similar situations to stand up for their rights. The policy changes that the HOA implemented as part of the settlement are significant. Now, before filing any lien, the board must verify payment status through at least 3 independent sources, including bank records. Homeowners must be given written notice of any alleged delinquency and a 30-day opportunity to provide proof of payment before any lien is filed. If a dispute arises, it must be reviewed by an independent third party before the HOA can proceed with collection actions. These changes might seem like common sense, but they were not in place before. Brenda had been able to file liens based solely on what a computer program told her, without any human verification or oversight. That was a recipe for exactly the kind of disaster that happened to me. Now, those safeguards are in place to protect future homeowners. The new board also established a grievance procedure for homeowners who believe they have been treated unfairly. There is now a formal process for filing complaints, requesting reviews, and appealing board decisions. It is not perfect, but it is better than what existed before, which was essentially nothing. Brenda had operated as a one-woman dictatorship, making decisions without input or oversight. That is no longer possible. I sometimes wonder what would have happened if I had just paid the $1,200 that the lien demanded. It would have been easier in the short term. I would have avoided months of stress, thousands of dollars in legal fees, and countless hours spent on the case. But I also would have admitted to something I did not do, damaged my own sense of integrity, and left Brenda free to do the same thing to someone else. More importantly, I would have missed out on the opportunity to grow and learn that came from fighting back. I would not have become as close to my neighbors, would not have met Marcus Rodriguez and learned so much about the legal system, would not have developed the confidence and resilience that have benefited me in so many other areas of my life. Sometimes the hard path is the right path, even if you cannot see it at the time. As I finish writing this account of my experience, I hope it serves as both a cautionary tale and an inspiration. The cautionary part is obvious. Be careful of who you allow to have power over your property and your life. Pay attention to your HOA, know who is on the board, understand the rules and procedures. Keep good records of all payments and communications. Do not assume that authority figures are always acting in good faith or have your best interests at heart. The inspirational part is this. If you find yourself in a situation like mine, do not give up. Stand up for yourself. Gather your evidence, find a good lawyer, and fight back. The legal system exists to protect people from exactly this kind of abuse. It is not perfect, and it is not always fast or cheap, but it can work. You have rights as a homeowner and as a citizen, and those rights are worth defending. What happened to me could happen to anyone. HOAs are everywhere, and while most board members are probably honest and well-intentioned, it only takes one person like Brenda Morrison to turn your life upside down. When that happens, you have a choice. You can accept it, pay up, and move on. Or you can fight. I chose to fight, and I won. Not just money, though the settlement was significant. I won my dignity, my reputation, and my peace of mind. I won justice, and I helped make my community a better place in the process. That is worth more than any amount of money. Looking ahead, I feel optimistic about the future. My relationship with Rachel is going well. My career is thriving, and my home is finally feeling like the sanctuary it should be rather than a source of stress and conflict. The settlement money is allowing me to build real financial security, something I had struggled with after the divorce. I am even thinking about buying a rental property as an investment, though I will be very careful to avoid anywhere with an HOA. The whole experience has also made me think about what I want to do with my life going forward. I have always been focused on my career in tech, but I realize now that I have a passion for justice and helping people who are being treated unfairly. I have considered going back to school for a law degree, though that feels like a huge commitment at this stage of my life. For now, I am content to be an informed and engaged citizen, someone who speaks up when he sees injustice and is willing to take action to correct it. I also want to use my experience to help others who find themselves in similar situations. I have started participating in online forums where people discuss HOA issues, sharing my story and offering advice based on what I learned. It is amazing how many people are dealing with abusive HOA boards and feel powerless to do anything about it. If my story can give them hope and guidance, then something good has come from all the stress and struggle. Marcus Rodriguez and I have stayed in touch. He calls me occasionally when he has a new HOA case and wants to discuss strategy or use my case as an example. He has told me that my case has helped him win settlements for other clients because he can point to the precedent we set and the damages that were awarded. That feels good, knowing that my fight has made it easier for others to achieve justice. The one thing I regret is that I never got a real apology from Brenda Morrison. The written apology that was part of the settlement was clearly drafted by lawyers and did not feel genuine. It said the right words, but there was no acknowledgement of the personal harm she caused or any real remorse for her actions. She never looked me in the eye and said she was sorry. Maybe that is too much to expect, but it would have meant something. Then again, maybe the forced apology and public humiliation were punishment enough. Brenda had to admit to the entire community that she was wrong, that she had filed a false lien, and that she had slandered me. She had to resign from the board in disgrace. Her reputation in the community was destroyed. She and her husband felt compelled to move away. In some ways, that is a harsher punishment than anything a court could have imposed. I do not take pleasure in her suffering. I am not a vindictive person. But I do feel satisfied that there were real consequences for her actions. Too often, people in positions of power face no accountability when they abuse that power. Brenda learned that actions have consequences, and hopefully, she will think twice before treating someone the way she treated me in the future. As for the Riverside Meadows HOA, it continues to function, but in a much healthier way. The new board is made up of homeowners who genuinely care about the community and want to serve their neighbors rather than lord power over them. Meetings are well attended and transparent. Decisions are made collaboratively rather than autocratically. It is not perfect. No organization run by volunteers ever is, but it is vastly improved. Property values in the neighborhood have increased by about 15% since the new board took over, according to recent sales data. Real estate agents who show homes in our community now mention the improved HOA management as a selling point. What was once a liability has become an asset. That is a testament to how much damage one bad board member can do and how much positive change can happen when that person is removed. I have also noticed that people in the neighborhood are friendlier and more engaged. There used to be a sense of fear and resentment toward the HOA. People kept their heads down and tried to avoid attention. Now, there is more of a sense of community pride and involvement. People volunteer for committees, attend social events, and look out for each other. It is amazing what a difference it makes when people feel like their HOA is working for them rather than against them. My own involvement in the community has been rewarding. I serve on the Architectural Review Committee, which approves requests for exterior modifications to homes. It is not a glamorous job, but it is important, and I try to approach it with the fairness and common sense that was so lacking under Brenda's reign. When homeowners submit requests, I make sure they are reviewed promptly, and that any denials come with clear explanations and suggestions for alternative approaches. I have also tried to mentor new homeowners who move into the neighborhood, explaining how the HOA works and encouraging them to get involved. I tell them my story, not to scare them, but to show them the importance of paying attention and standing up for themselves if something seems wrong. An informed and engaged community is the best protection against the kind of abuse I experienced. The financial impact of the settlement has been significant for me personally. After taxes and legal fees, I netted about $42,000. I put $20,000 into a high-yield savings account as an emergency fund, something I had never really had before. I used $10,000 to pay off the remaining balance on my car loan, which freed up several $100s a month in my budget. The remaining $12,000 I invested in a diversified portfolio of index funds, following advice from a financial planner I consulted. For the first time in my adult life, I feel financially secure. The divorce had wiped out most of my savings, and I had been living paycheck to paycheck for a while after that. The settlement gave me breathing room and allowed me to start building real wealth. It is a strange irony that Brenda Morrison's abuse ended up putting me in a better financial position than I would have been otherwise. But life works in mysterious ways. The emotional impact has been equally significant. I came out of this experience with more confidence, more resilience, and a stronger sense of self-worth. I proved to myself that I could handle a serious crisis and come out on top. That knowledge has been invaluable in facing other challenges that have come up since then. When work gets stressful, or I have a disagreement with someone, I remind myself that I took on an HOA board president and her lawyer and won. Everything else seems manageable by comparison. My relationship with Rachel has also benefited from the confidence I gained through this experience. She has told me that one of the things she finds most attractive about me is my willingness to stand up for what is right, even when it is difficult. The fact that I fought the HOA rather than just accepting an unjust accusation showed her that I have integrity and courage. Those are qualities that matter in a relationship. As I reflect on everything that happened, from that moment I saw the Lien notice on my door to the day I signed the settlement agreement. I am struck by how much can change in a few months. My entire life trajectory shifted because I made the decision to fight back rather than give in. If I had paid that $1,200, I would have avoided a lot of stress, but I also would have missed out on so much growth and positive change. The experience also reinforced my belief in the importance of the rule of law. We live in a society governed by laws and legal procedures, and while that system is not perfect, it generally works to protect people's rights and hold wrongdoers accountable. Judge Sullivan saw through the HOA's nonsense immediately. Marcus knew how to navigate the legal system to build a strong case. The insurance company recognized the legal reality and agreed to settle rather than risk a trial they would lose. All of that happened because we have a legal system that provides forums for resolving disputes and mechanisms for holding people accountable. In some countries, someone in my position would have no recourse. The person with power would win simply because they have power. But in America, even a middle-class software developer can take on an HOA board president and win if he has the facts on his side and good legal representation. That is something worth appreciating and protecting. Our legal system is under strain from many directions, with growing backlogs in courts, increasing costs of legal representation, and declining faith in institutions. But cases like mine show that the system can still work when it needs to. Justice may be slow and expensive, but it is achievable. I want to close this account by thanking everyone who helped me through this ordeal. Marcus Rodriguez, my attorney, who took my case seriously and fought tirelessly on my behalf. Judge Patricia Sullivan, who saw the truth immediately and was not afraid to call out the HOA's misconduct. Tom Chen, Susan Phillips, Michael Torres, and the other neighbors who supported me and provided testimony. My boss and coworkers who were understanding when I had to miss work for court appearances and depositions. And Rachel, who came into my life just as things were resolving and has been a source of joy and support ever since. Most of all, I want to thank my past self for making the decision to fight. It would have been so much easier to just pay the money and move on. But I chose the harder path, the path of integrity and justice. That decision changed my life for the better in ways I could not have imagined at the time. It taught me that I am stronger than I thought, that standing up for yourself matters, and that justice is possible if you are willing to fight for it. To anyone reading this who finds themselves in a similar situation, dealing with an abusive HOA or any other unjust treatment, I encourage you to stand up for yourself. Document everything, find good legal representation, and do not give up. The fight may be hard, but winning is worth it. Not just for the money or the tangible benefits, but for the knowledge that you stood up for what was right and prevailed. That is the story of how I fought my HOA and won. It is a story about injustice and accountability, about power and abuse, about standing up and fighting back. It is my story, but it could be anyone's story. HOA abuse is unfortunately common, but so is the ability to fight back and win. I hope my experience inspires others to do the same.